issues and you put a hole in the wall, or they can terminate the contract if the seller refuses. They can do any of those above. It is their right if the house is in worse condition than when they saw it previously. Now, hopefully, at this point, you're going to be able to negotiate and get this corrected so that you don't terminate. Who closes the transaction?
Seller's attorney.
In North Carolina, we are an attorney-based state for closing. So typically, all your paperwork that you've received, all the addendum, all the contracts, everything that you have done so far, you're gonna send to the attorney when you get it, the final contract. Now, in some cases in North Carolina now, we do allow title companies, so long as they have an attorney that's on staff. And then they may have somebody else do the closing and then they verify it. But for the most part, we are still an attorney-based state, and we do demand that a real estate attorney do the closing. And that attorney is responsible for making sure that they have all the pertinent information. They know they got to contact the buyer and the seller for as far as funds, because the seller is going to receive funds after closing, and they want to know if they want a cashier's check or a check out of their trust fund, or they're going to have money wired. They got to contact them to get their loan information. They got to contact and find out about title insurance. All of these are things that are done through that they need to contact information for the listing agent and the seller so they can reach out. Because what is the one thing that you are not going to ever do? Not interpret. You are not going to receive wiring information from the attorney and forward that to your client to wire funds. All attorneys now require wiring. If it's over $5,000, they cannot bring a check to closing. And they're going to require wiring. And because of loan fraud and wiring fraud, you now do not want to be involved in it, because the last thing you want to do is, for years it was pretty standard that the attorney gave the buyer's agent wiring information. We had direct contact with our buyers and we gave them the wiring information to wire the money. But now there's so much loan fraud that in between the time that we do, these people are going in and hacking emails. And when they hack an email, they are now getting the information, and then they're sending you a new wiring information. You don't even think about it. You open it up and everything looks identical to what you've already sent, except they replace a letter. Let's say on my attorney, the attorney that we typically use is Bailey and Busby, and their email address is @baileybusby.com. There's nothing that says that I look at it, I know it's Wilmington @BaileyBusby. That's the typical thing. I forget what their trust fund starts with, but what they typically do is they have this name in the trust fund, and then it goes into their trust fund. Well, all somebody has to do is reverse one letter. It might say B-I-A-L-E-Y. Now I just look and see Bailey Busby because I've done it for 15 years. I don't think about it, so I forward that email with their wiring information to my buyer. And they wire $300,000 to that account. They're paying cash for a house. And then they go sit at the attorney's table at the settlement, and they say, when do I get keys to the house? And the attorney says, as soon as I receive your $300,000. And they look and say, I wired that to you 48 hours ago. And they show it. And then the attorney verifies, this is not our trust account. So what you want to make sure of is you do not pass that information on. Your buyer should call the attorney's office, and the attorney is going to send them a welcome letter saying, thank you for choosing us as your attorney. We will be giving you this information for wiring, et cetera, et cetera. And then closer to time before closing, contact our office and we will verify wiring instructions. And then the buyer's going to get it when they go to the bank, and they can have the money directly wired. Typically, the best case scenario is when your buyer goes to the bank, is they have to tell or call the attorney and say, your client is getting ready to wire funds and we want to verify your wiring instructions before we wire the money. And every bank will do it, every teller will do it, because they're all aware of the wiring fraud. The other issue is sometimes they're wiring money to the seller. So if you're representing the seller, you do not want to be the one to carry their banking account information to the attorney or emailing it to the attorney. Because all you have to do is transcribe one number wrong, do anything wrong, and the money goes into the wrong account. So the sellers need to make sure they tell the attorney that we want money wired and furnish them the information they want it wired to. So keep that in mind, as you need to stay out of that transaction. You also do not want to collect social security numbers from your sellers. They have to have it because they have to give them the tax information at the end of the year to the IRS as far as the sale of the house and the profit. But you do not want to be the one to write down their social security number and email it or any way transcribe it to the attorney, because your emails can be hacked. And you're putting personal information for somebody out there for somebody to get a hold of. So all that information needs to be handled from the attorney directly with the seller or with the buyer to the attorney for as far as wiring information. One of the biggest issues, and I cannot stress this enough, one of the biggest issues right now, and you've heard about it in the offices where you work, you've heard about it all, is the fact that all the wire fraud that is going on. And it is prevalent in our area as across the state. So be careful about that. Do not get yourselves in any way handling that. The other thing that you want to make sure of is the fact that you do not pick up checks at the attorney's office to distribute. If they're wanting a check, make sure the seller picks up their check or the attorney emails it or wires or mails it to them. You do not want to pick up the check and deliver it to your seller. You can pick up that check, lose it, and then the attorney can't write another check right away. They got to wait and make sure that that check has not cleared the bank. So there's time, there's days. And then if it goes beyond a certain window, the lender's going to require the loan papers to be re-signed because it can't be recorded for whatever reason. You got to be careful about all these things whenever you're in there. So you just need to make sure that you do not do anything requiring any of that.
So, say it does happen, and the lawyer gets fished or whatever, who's liable? The lawyer, I guess? Or
To hear Mac's question, who's liable if it happens, that is a big debate.
Okay.
I'm not going to tell you in all cases, because I can't tell you in all cases what has happened. I can tell you in one particular case that the attorney ended up making it right. I do not know all cases. In some cases, I know that agents may be responsible if they lose checks and so forth. I do not know of any agent's been held liable for getting wrong wiring information, but I don't know that. I just don't know any person. In my contract, the seller agreed to pay $2,000 in closing costs. What costs are included in that $2,000?
Attorney fees?
The attorney fees can be included. You heard Michael? Okay. It can be any cost. What they do is they typically are going to itemize. Most of you know by now that whenever you've done, the typical fee that is used for closing costs is 3%. You can go up or down based on the value of the house, but 3% is the average. And most lenders will allow you to collect 3% in closing costs based on your loan. Some loans are more, for as far as how much the seller is allowed to pay towards the closing costs. So what they do is they will actually just take the $2,000 and apply it towards whatever is normally charged to the buyer, and then they'll give them credit for that at closing. So it can be any of the closing costs involved. It can be the home inspection, it can be the loan commitment, it can be any fee that's added to the attorney fees. All that cost is added to it. Any other question about closing costs? I am being asked to put something on the statement that is different than what I agreed to. Is that okay?
No.
I can't even imagine that somebody, but there are times, especially, 12 years ago, 15 years ago, that could have happened. where people are adding things in, they're committing loan frauds and different things, but the biggest thing now is the fact that you wanna make sure that everything that's on that paperwork is legit. Make sure that there's no invoices that are created so that the seller's paying more money or paying something that they're not required to. Remember, it is your responsibility on closing disclosures that you have to verify your client's expenses and making sure they're accurate. So you're signing off saying that everything on here is correct. So what you don't want to do is see an invoice on there that you say, we didn't do that, and let it go through. So it's up to you. You've got to be honest about this too. I can tell you, I haven't had one ever ask me to do that. But I won't tell you that it hasn't happened out there. I feel quite sure of that, back in 05, 06, 07, that happened. So. Any other questions concerning that?
What sort of things do you mean when you say invoices? Invoices for what?
Let's just say that your buyer needs some extra money for closing.
Okay.
And so the seller says, well, why don't we just do an invoice for labor that was done to do some repair work that wasn't being done? So they're getting credit for $500 on the closing disclosure that they're getting credit for. That work wasn't done. Okay, so it's up to you to verify these expenses and make sure. What is prorating?
Splitting the expense.
Splitting the expense. Y'all heard rating? Basically, you got to prorate taxes. The seller has to pay from January through the day of closing. Remember, they own the property the day of closing, and so they pay from the January 1 through the day of closing. And there's buyers getting credit for that if it's prior to August, when the tax bills go out. After the tax bills go out, the attorney's going to collect from both sides of the hand. Rent, if the house is an investment property and there's a tenant in place, remember the seller still owns that property up to the day of closing. And they collect the rent through then, and then the rest of the month is credited to the buyer. What are special assessments?
Sidewalks.
Street, sewer lines.
Did you hear Christie? Sidewalk is one.
Sewage.
Sewer lines,
Street repairs.
street repairs, so they're paving your street. And what they're gonna do is they're gonna assess everybody for their portion of it, and you're gonna make monthly payments for these things until it's paid for. And if you sell the property and your buyer is the one buying it, you wanna make sure you know these special assessments, because you wanna ask for them to pay those off at closing, so that your buyer is going in without that debt. If I'm a seller, when should I get my proceeds from the sale of my property?
After closing from the attorney.
Did you hear Jeffrey? After closing from the attorney. And that is correct, it's after closing. You go to the settlement table and they sign loan docs, and then the attorney records it, and that's classified closing. After it's recorded, buyers and sellers can pick up refunds, and the buyer gets money back, the seller gets his proceeds, and the buyer can get keys to the property after recordation.
Right.
Who owns the property up until then?
The seller still.
The seller owns it. So between the time you're at the settlement table and it is recorded and the house burns to the ground, whose house is it?
Seller.
The seller. There can be some negotiating for as far as the other, but it's the seller's property. So you do not want to have your buyers have a key to the house and them moving in and set the place on fire. What if I can't close by the time stated on the contract?
Isn't there an extender period? Extender clause or something?
Dear Jeffrey, there's an extender clause in our contracts. How long is it?
14 days.
14 days. So based on your closing date that's in the contract, you have 14 days from that day in order to close or get an extension. That doesn't mean that in 14 days it's void. It's voidable. The seller does not have to give you an extension, but they can give you an extension until you close, but you have 14 days from that date to close in our standard offer to purchase. Now, if the attorney did any different addendum, if there's anything else that you added to it, then that's part of the contract. Any other questions that you may have concerning them? Okay. All right, we're gonna divide up into groups, 3 each. You'll take these, and you'll take these and pass them around. This is just these are just mixed up words dealing with what we're dealing with here for part and closing. Y'all will just work together, because what I want you to do is not just do the word. What I want you to do is look at the word and then write down what that word means. You need a clear understanding of what you're writing down so you understand the word definition.
I just can't spell right.
Make sure you write down what it is. Don't forget to write the definition.
So I gotta just like get them all.
Make sure you write me a definition.
The third one. Oh.
Yeah, right, that's really how it's going around.
How far along are we? Okay, we got a couple more minutes. Yes.
That would be
Y'all have that?
18, Craig, for the 18.
Ready to get followed up?
Get all the words first.
Value. In the section, find the value.
We'll write down the words first and go back, we'll talk about some of them.
Oh, okay, all right.
The words are basically.
Yes.
Let's just get that one.
I give you about 2 more minutes, and then we're gonna do the class. saw a word on there that you didn't talk about in pre-licensing, right? Or that Pat hasn't already gone in your post-licensing class.
For that too, and check for encroachments and.
One more minute. Okay, let's go ahead and stop at this point, and we're gonna go over them so that we can move on, so that we can have a break. All right, number one. What's the word?
Appraisal.
And what is an appraisal?
Finding the value of the house.
Who does an appraisal?
Appraiser.
Appraiser. Do you ever do appraisals?
No.
No. As a provisional broker, what else do you not do? BPO. Y'all do CMAs. Number two,
Due diligence.
what is due diligence?
It's a period of time to perform inspections that are opt out of the contract for any reason that you want to.
That is correct. Any reason whatsoever you choose to leave the contract, you can. Keep in mind, our contract does not give loan commitment for due diligence. Most often, your due diligence is going to expire before you get a loan commitment. So you need to be very careful and make sure that your clients are on go with their loan before your due diligence expires.
So would you?
You can ask for it. Did you hear what, Jacob was asking? Jacob is asking whether or not, what do you do if you don't get loan commitment? One is you can terminate if you don't feel comfortable with the loan. Two is you can ask for a due diligence extension. The other is what typically is that you're going to make sure that loan is really good. By 2-3 weeks into it, and usually most due diligence periods in our area are 3 weeks. And within 3 weeks, you should have a pretty good idea of the status. The hiccup we already talked about are, things. The other thing that comes up is what are you going to advise your buyer to do whenever you're doing a loan after they go under contract? Don't go out and buy anything. Don't do anything that's going to change their credit. And those things do pop up. Those are some of the reasons that loans do not close on time. We have to get extensions. We have to go back and fix them. So you make sure that you tell your clients that once you're under contract and you're in this period of pre-closing, do not buy anything. Do not do anything to change your credit score.
Like shopping for new furniture for the new house.
You can shop, just don't buy. I've had one that came up and it showed all of a sudden a new $3,000 credit card to, one of the furniture companies over on
IKEA.
College Road. And what they did, they didn't go buy it.
Just get.
They didn't do anything. What they did was applied for credit. And that application for credit hit their credit. And so it showed them a $3,000 limit now, and that affected their credit scores. So be careful and make sure you tell your buyer, do not do anything during this time frame. Third one,
Home hazard insurance.
and I know most of us don't refer to it as home hazard insurance. We either call it home insurance, we call it wind and hail. All of it is combined, they just home hazard insurance.
That's why we didn't recommend.
4,
Title
title insurance. And title insurance,
protects the lender, buying and seller.
it protects everybody involved in it. The reason that we do title insurance is because the lender needs to protect it if something happens to a third party. And you know, in most cases, that the person who sells the house may or may not ever be capable of really clearing any title issues up or coming forward financially. Number 5,
Settlement date,
and what's the settlement date?
date for closing.
The date set for the closing, for you to come into the attorney's office. Is that date set in stone? No. Number 6,
Survey,
survey. We know what the survey is, correct? And we know what purpose it does. 7,
inspection,
and during that 3-week window, you need to have all your inspections done. All the inspections should be completed, repairs negotiated. Do repairs have to be done during your due diligence period?
no.
No. All we're required is to have the repair request agreed upon, negotiated, signed. The sellers have until the day of closing to make sure all the repairs are done. 8,
Title search,
title search. Who does the title search? What's it for?
it's to make sure there's no clouds on the title, and go back like 30 years, is it, through transfer?
Minimum of 30. We go back further if we can, and the attorney does that search. And then he writes a letter to the title insurance company, which explains and says that he saw no reason why the title insurance cannot be issued, but that's a title search. There are 2 title searches done on a property during this process. The first one is a preliminary. It's a 2-year chain of title. All they're doing is verifying that the owner's owned it for 2 years, there's no issues arose during that time frame, so that the lender can proceed with the loan. And then from then until closing, before the CDs go out, closing disclosures, they verify that there's no clouds and everything's clear, and then they move forward. Number 9,
Attorney,
and the attorney's the one who does your closing. Number 10,
offer to purchase,
and the offer to purchase becomes contract. Number 11, contract. Number 12,
addendum,
and all the addendum are those pieces of paperwork that are attached to the contract that are pre-printed. Because what do we not do as brokers?
fill in anything.
We do not draft any documentation. We fill in holes, blanks on contracts. If there's any changes to that, it has to be done by the attorney. Number 13,
Earnest money,
earnest money. And earnest money is your good faith money towards moving towards the purchase of the property. And number 14,
offer,
and who is the offeree?
seller,
And remember, the buyers, you're typically your original offeree. He's the one presenting an offer to the seller. And then if they negotiate, if they want to make changes, then the seller becomes the offeree back.
counter, okay.
Okay? Or actually, they're the offeror back to the offeree. Correct?
Yes.
Okay. The offeror is the one making it, the offeree is the one receiving it. Number 15,
Covenants,
covenants are your HOA that we talked about. Any questions about these 15?
No.
Okay. All right, these are the things that we've talked about, your due diligence period. We need to make sure all the material facts are disclosed. Anything that's being done with the contract, before the contract, we've already talked about that. Good practice to work well with the mortgage originator. The buyer can shop for as far as his loan. We need property insurance, flood insurance if you're in a flood zone. So make sure all of these things are being done during your period of due diligence. Flood insurance is a major thing. Inspections, make sure all of these things are done. Tenants and leases, make sure you have all that paperwork. Sewage and postal systems, we've talked about every one of these. Every bit of this is very important during that time frame that you have gone from contract to closing. You've got to make sure you cover all of these issues. Flood, We're on the coast. Do you think we have a lot of flood areas?
Yes.
We have a lot of flood areas. A lot of flood areas you wouldn't even think are flood areas because they got hit back during 98, 99 when we got hit with hurricanes. And so there are several areas that normally have been dry, never ever had water. And then all of a sudden, during that 2-year period with all the hurricanes, they got flooded. And so they got hit down there in the flood zone. So they had to pay flood insurance. And because the government subsidizes, if they have an existing flood policy, it is transferable to your buyer. If they pay cash or they paid off, they may not cover flood insurance anymore. And then it's purchased through the insurance company at a higher rate. The government does not subsidize new policies. So keep that in mind when you're doing it. I had one that was happening on the water. Bought the house, its first year's flood insurance was $9,000, $10,000, because there was no insurance on the property. He called the insurance company and said, what can I do to reduce this? They told him what to do. Reduced his flood insurance. Year 2, after he did all the changes, he spent over $100,000 in renovations. But after he made the changes, they reduced it to less than $1,000. So you've got to stay in touch and make sure your buyers are aware. The title search, the attorney does, clearing all defects, make sure that they assign outstanding leases, and all the final pre-closing procedures. All those procedures have to be in place and done. The attorney, you talk about it in pre-licensing for as far as the procedure, for as far as at the closing table, for as far as they're going to go over the closing disclosures. There's 2 of them, correct? So you're going to go over all of that the next hour, because that's going to be part of the closing. But you just need to make sure you have discussed what's coming up in the closing disclosure, so your buyer and your seller understand that they don't see each other's side anymore. Those days went away when the HUD went away. We get closing disclosure for a buyer, closing disclosure for a seller, and neither party sees the other. Now you as a broker get to view the other sides. We didn't used to have that. You could only verify the numbers that were on your side. But now they have cleared it so that we're allowed to see both sides. You cannot share the information with your client, but you're allowed to see both sides of the closing disclosure, because you're representing the seller. You want to make sure they give them credit for more money than what they did for their closing costs. And on the buyer, you want to make sure they got all the money that they could get. So you're reviewing both of them. And then the attorney's going to make sure they can get the title insurance. Now, we're going to let you go take a break, and in the next hour, we're going to talk about the closing procedures. For as far as you've got the pre-closing done, all these are done, you're beyond your due diligence, you're getting ready to close, and now we're going to talk about the procedures at the closing table. So y'all, if you will, thank you very much for this hour, and I'll see you after your 10-minute break.
Thank you.
Thank you.